Oh,
Oh, we're live. Hello to anybody who's tuning in. My name is David Gottlieb. I'm a partner at Wigdor LLP. I hope everybody is healthy and safe on this Friday. If you've been tuning in, you may know that we've been doing these videos periodically during the pandemic to help address pertinent legal issues that are arising under these unique circumstances. And I'm joined by my colleague Hillary, who's a veteran to these presentations. And Hillary, I'll let you introduce yourself.
thanks, David. My name is Hillary Orzik. I'm an associate at Wigdor LLP. I work with David on various employment discrimination, sexual harassment, and other employment law issues. And then I'll give it, we have a special edition of this week's YouTube where we have a more concentrated topic, and we'll be talking about various accommodations that individuals can be eligible for and questions that you might have as you re-enter the workplace. So I'll take it back to David just to talk a little bit more about Wigdor LLP and what we'll be discussing today.
Great, thanks, Hillary. So yeah, before we get started on the presentation to cover the topics Hillary just mentioned, I'll speak briefly about our firm. We are a civil rights firm. We primarily represent victims of all forms of discrimination, harassment, and mistreatment in the workplace, though certainly not exclusively limited to the workplace setting. So the types of cases this involves are discrimination on really any prohibited basis. Those include gender, pregnancy, sexual orientation, race, disability, age, religion, and retaliation against people who have blown the whistle on this sort of discriminatory or any other sort of unlawful conduct. It also includes people who are not being paid appropriately or people who are being denied other rights that they're entitled to in the workplace. Needless to say, the pandemic times we are all living in right now and that will remain for the foreseeable future has generated numerous questions about employees' rights, unique circumstances that we've never addressed before. And through these presentations, we've been attempting to address those questions. Before moving on to our topics, I just want to add that we cannot give legal advice today. We're going to be giving a presentation which will overview certain legal issues that are being highlighted right now. We'll be focusing on New York law because that's where our firm is located. But again, this presentation is for informational purposes and we cannot provide legal advice. If you do need legal advice, of course, you should reach out to an attorney, whether at our firm or another firm, because any situation really requires a detailed analysis of a particular set of facts, which would be too voluminous to go through hypothetically now. So with that, just a brief outline of the presentation. First, as Hillary mentioned, I'll be addressing an issue that many working parents may be wondering about, and that is whether and to what extent working parents are entitled to childcare accommodations or are entitled to job protection during the pandemic. And then the second phase of our presentation will be addressing, given Governor Cuomo's recent announcement of a 4-phase plan to reopen New York businesses and just a more general discussion that's ongoing about opening up the economy around the country, Hillary will be addressing legal issues that are likely to arise upon people returning to work. So that's going to be the general outline of what we'll be discussing. With that, I'll start by talking about rights working parents have during this time. So I wrote an article for the New York Law Journal. This was a couple of weeks ago, longer than that, in fact. This was just after the Governor Cuomo issued his initial executive order shutting down businesses in New York other than for essential workers. And Jacob, if you could just post the link to that in the chat function so people can view it at their leisure if they'd like. Now, the reason I wrote this article is that after the work from home order started, we were hearing from a lot of people that they were working from home and having to do their full-time job from home, which created its own set of difficulties with lack of the similar equipment and supplies and support that people were used to working from the office. That coupled with they had children at home and their children weren't able to go to childcare, were not able to go to school, and they had to care for their children all day. And so this just created a situation for a lot of people. I shouldn't say created in the past tense. It continues to create a difficult situation for people who are now doing really 2 full-time jobs under less than ideal circumstances. Of course, the 2 jobs are their regular job and then the job of caring for their children. And for a lot of people, this creates a really untenable situation. I speak from personal experience. I have a young child, and I can certainly attest to the challenges that having a young child and working from home at the same time create. So, for many people, this creates obligations that are really challenging to take care of, and very few people want to tell their boss that they can't do their job because for any reason, even if there's a good reason, because people are fearful of even in a good economy of losing their jobs, let alone in an economy now where companies are making layoff decisions, on a daily basis. So that's why the article I wrote touches upon, what rights employees have who are also caring for children, and whether they can and to what extent they can seek accommodations for their childcare needs under the law. Unfortunately, like most legal issues, the answer is not straightforward and clear cut. But first, let's look at New York law. Under New York state law, a law called the New York State Human Rights Law, an employer cannot discriminate against or treat an employee differently because of their familial status, and that includes the status of being a parent. And similarly, under New York City law, the New York City Human Rights Law, an employer cannot discriminate against an employee due to their caregiver status. So those are different terms, but they both cover working parents. So under both laws, it would be unlawful for an employer to be in any way motivated, even in a small part, to take any action against an employee because the employee is a parent or because the employee cares for children. So just as a hypothetical, if an employer engages in layoffs and in the layoff process has to make decisions about who to terminate and terminates employees, maybe partially for economic reasons, but then partially because they think it's better to get rid of the employees who have additional childcare responsibilities. That would be unlawful. It would be unlawful under New York State and New York City law to make those decisions, even if they're partially based on someone's being a parent or having children to care for. And we've been seeing cases like this come up quite a bit because, of course, companies are having layoffs all across the state and all across the country. And there's a term for this called recessionary discrimination, when a company uses a layoff to terminate employees who it may deem problematic. Childcare responsibilities may be one issue, but there could be any number of issues. For instance, if an employee has made a complaint of discrimination and they view this as an opportunity to get rid of a problematic employee. But for purposes of our presentation, certainly if an employee is terminated as part of a layoff because of childcare responsibilities, that would be unlawful under state and city law. Turning to federal law, there is no anti-discrimination law at the federal level protecting familial status or caretaker status like under the laws I just mentioned. But that's not the end of the question. So very often, discrimination on the basis of caretaker responsibilities is really a proxy or an extension of gender discrimination. Gender discrimination is protected by federal law. So even if you're outside of New York State and the state or locality that you're in does not have a more protective anti-discrimination law, you still may be entitled to protection under federal law through the prohibition against gender discrimination. So, so again, while we're focusing on New York law, if you believe you've been terminated or mistreated because of your responsibilities as a working parent, you still may be protected under federal law. And again, you should speak to a lawyer about that. Now, what if the issue is not that you're being mistreated, but you just need help handling both your work and your parenting responsibilities? So this is what we mean by childcare accommodations. Unfortunately, under any of the laws, federal, state, or city law, there is no express legal obligation for an employer to provide childcare accommodations to working parents. But for the reasons I mentioned moments ago, you cannot be treated differently for requesting such accommodations. So as an example, if you ask for, let's just say as an accommodation to the fact that you have childcare responsibilities, you ask for additional time to complete a particular assignment or project, and similar sorts of extensions are being provided to other colleagues and coworkers, it would be unlawful to deny your request because it is tied to, your childcare responsibilities. It would also be unlawful to terminate you because an employee has requested a similar accommodation, because that would effectively be terminating the employee for the underlying status. Many people have questioned, okay, so even if you can ask for accommodations, what sort of accommodations are there that you can request? Because to some people, there's no fix to this situation. No matter what accommodations could be provided, there's really nothing that can fix a situation where you're doing, two jobs that require full-time attention, full-time commitment. And on that question, what I've been telling people, and I really think it's important to keep in mind, is there's no exhaustive list of what an employer can provide to an employee as an accommodation. And I really urge anybody who needs accommodations of any kind, who needs help. Accommodations can sometimes sound like an overly legal word, but you need help. And what I really urge everybody to do is really be as creative as you can be. So one thing that means is don't just rely on your employer to come up with a plan or to come up with accommodations that may help. You probably understand your situation and what might help better than anyone else can, better than maybe somebody in HR or a manager can, because you know your situation better than anybody else. So one thing you can do to help yourself is really be creative to think about what could make the situation better. So, I'll just give some ideas, but there's really, again, no exhaustive list. Some ideas might be, flexible hours. Let's say you need to care for your child in the morning, and then afterwards your spouse, takes over for the afternoon. You could ask for flexible hours to start later in the day and maybe work later in the day. You can ask for designated breaks if that may be needed for childcare. So you could ask for a break in the middle of the day or a break at some point during the day. You could ask for a flexible schedule. That could include, instead of a day off being on Saturday or Sunday, you could ask for a day off midweek, or you could ask for, to work half days at different parts of the week. And that's something that may accommodate your schedule. Like I mentioned earlier, you could ask for extensions on deadlines and on projects and assignments where maybe deadlines are being set where they're not needed or where they're unrealistic. And this is, I think, an important one. You can ask for additional equipment and supplies to be sent to your home. Right? I think part of the issue a lot of people are having is instead of working at a big desk with all of your supplies and equipment and your desktop computer with your multiple monitors, a lot of people are on a small desk, particularly in New York City, in people's apartments, on a small desk with a small laptop computer with a small screen. So you can ask for additional equipment that can help you maybe mimic the more productive workplace that you have in the office rather than at home, and ask for your employer to purchase those things for you and send them to your home. There could be software that can help. So, I mean, these are just ideas that maybe if you're watching or listening and you hadn't thought of, these are just some ideas that can help, but there could be any number of other things that might fit your particular situation and the particular situation of your family, particular situation of the type of work that you do. So, so really just, I can't emphasize enough that you should really be thinking creatively. Employers are certainly thinking innovatively to keep businesses operating. So I would put a similar onus on employees to really think creatively about what your employer can do to help you. Like I said, if you make a request for any of these sorts of accommodations and that request is denied, that could constitute discrimination and be unlawful. Of course, it would all depend on the circumstances. The final thing I'll address is how to request accommodations. So most employers, though not all, have employee handbooks. Employee handbooks are required under some laws, so they are pretty common, particularly for employers of any size. But some smaller employers don't have handbooks, which I'll get to in a moment. But if your employer has a handbook, you should review the handbook. It should say if you have a request for accommodations of any kind, who that should go through. And I would just recommend following that procedure. Usually it's going through somebody like an HR representative or HR manager, an office manager. Those are the typical people who handbooks will designate as the appropriate point of contact. Though very often it can include any manager. If for whatever reason you feel uncomfortable going through somebody in HR, maybe the person who's designated in the handbook is somebody you're having a problem with, usually any manager will suffice. Certainly if your employer does not have a handbook, then you would need to go through a manager. Going through a coworker or a colleague would usually not suffice. So there's usually no obligation that an accommodation request be in writing. So if you're thinking about, okay, now you know you want an accommodation, you've reviewed your handbook, and you know who to ask for the accommodation from, usually there's no obligation for it to be in writing, but generally speaking, it is a good idea to put these requests in writing. That way there's just no question and dispute about when you asked for something, what you asked for, and how your employer responded. So it is usually a good idea to put these sorts of requests in writing. And when I say writing, an email is a writing, so it just means have it documented. You certainly don't need to write it down in ink, and that really covers it. So, I mean, like I said at the start, this is just a very brief overview of the rights that working parents have and some of the ways that working parents can help themselves in terms of seeking accommodations. But any particular situation, for actual legal advice, you really need to speak to an attorney because the laws are like I mentioned, not always straightforward, and a lawyer can really help answer your questions in more detail. Were there any questions in the chat? I don't think so.
No, not at this time. And just a reminder, if anyone has questions, you are welcome to ask and we'll address them as we receive them. Or if you want to wait until after, then we can address them next week or separately by email. But if you do have questions, you can include them in the live chat on YouTube or Facebook, or you can send us an email at contact@wigdorlaw.com. So contact@wigdorlaw.com.
Great, thanks, Hillary. Great. So now, again, I know that was a lot I ran through. I believe the New York Law Journal article was also posted for anyone to see. So that that will help and be kind of just a summary of everything I just talked about as well. With that, I think we can move to some of the legal issues and questions that people have that will arise upon people's return to work. I'll just very briefly mention that Governor Cuomo issued earlier this week a proposed 4-phase plan for businesses reopening. There's not a lot of detail to it, and there's certainly no timeline. All we know at this point is that the current order that keeps the status quo, meaning only essential workers can work and everyone else is directed to stay at home, that goes through May 15th. And so there will be updates shortly, I'm quite sure. But I mean, very briefly, the proposed 4-phase plan starts with phase 1, opening of construction, manufacturing, supply chain, and select retail for curbside pickup only. That's stage 1. Some people may be wondering, what is select retail using curbside pickup only? And we don't know the answer to that yet. So that is, that's just a question that will still be answered. Stage 2, and again, we don't know how long stage 1 will last. There's been no guidance on that from the governor's office. Stage 2 would include professional services, finance, full retail, administrative support, real estate and rental, leasing. Stage 3 would include restaurants, food service, hotel and accommodations. And stage 4 would be recreational businesses, arts, entertainment, movie theaters, museums, things like that, and education. So we don't know when any of this will go into effect, unfortunately. There's a lot of uncertainty still. But again, as businesses do start to reopen, we anticipate there will be many questions that people will have, and Hillary's going to speak to some of those issues.
Okay. Great, thank you, David. So I'm now going to address some questions that might come up as people get ready to re-enter the workforce, as well as some accommodations that people may request or that employers may want to provide their employees. So let me go ahead and share my screen here. Right. And so we're just going to go through a few questions that we've prepared. And if anyone has any additional questions that they want to ask or have us address, please don't hesitate. So the first one is, can my employer require me to return to the office even if I am able to work from home and have been doing so successfully for some time? So I'm going to give the lawyerly answer of it depends. And this depends on a lot of factors. So first off, as far as the guidance that we have so far, there really hasn't been a lot provided to us by the government, on a federal level, New York State, or at the city level. So the first question that we really need to ask when we look at this is, who is the employer and what kind of business is it? So as David explained, there are going to be multiple phases into re-entering the workforce. So if you are in the phase where your employer can reopen, where you can be asked to go back to work, it's possible that the employer can require you to return or cannot require you to return. Unfortunately, the guidance isn't entirely clear as to what your employer can require you to do and on what basis. So if you are able to work from home, you've been doing so successfully for some time, and you'd just like to stay at home, and there's not necessarily a medical reason why you need to stay home. So, for instance, you're not immunocompromised, there's not, you haven't been diagnosed, or you're not exhibiting symptoms. It's possible that your employer can still require you to return to the office. That said, we're still waiting for more guidance from the EEOC and from other administrative agencies or state agencies. But as of right now, it looks like unless there is a medical reason why you cannot return to the office and you're in the phase where your employer can legally reopen, they may be able to require you to return to the office. So moving on to the next question, can my employer require me to return the office before New York enters into the phase that covers my type of business? So the answer to that is probably not. So the way that the phase system works is that the phases are based on the industry that your business is in. As David mentioned earlier, what businesses are included in which phase right now, it's a little unclear, right? What is a select retail business? We don't know the answer to that yet, and we hope that as we enter that phase, we'll get more clarification as to what is included and what is not included. As of right now, we're not entirely sure who exactly belongs in which phase. But if you're, as we get more guidance, we have a little bit more explanation, it should be more clear whether or not your employer is included in that phase. And if they're not included, they're not supposed to be opening just yet, then the employer should not require you to return to the office prior to that phase. Next, as the office is reopened, can I request to continue working from home? So the answer to this is, can you request it? Absolutely. The legal question is, does your employer have to grant that request? And that will go to what I was talking about before, where it depends on why you're requesting it, whether there's some sort of medical need for you to stay home. The EEOC's current guidance asks that offices be creative and that they be as accommodating as possible, particularly when it comes to teleworking and telecommuting and letting people stay home if possible. That said, this is just guidance and recommendations. So, what an employer is required to do at this point is still a little unclear.
And maybe I'll actually add to that, Hillary. I mean, some people may be wondering, can we go back to that last slide, Jacob? Yeah, so some people may be wondering, in tandem with what I was speaking about, childcare accommodations, if my employer asks me to come back to work and I cannot because the schools are not open or childcare facilities are not open, can it be held against me that I'm unable to return to work? Can an employer terminate me because I'm unable to come into the office? As Hillary nicely put it, it depends. We certainly hope that employers will accommodate people in that sort of situation based on the 4-phase plan Governor Cuomo mentioned. I mean, education is in stage 4, so schools may not open until quite a while after other businesses are open. But an employer is not obligated to keep an employee on payroll if that employee is unable to do its job responsibilities, and that part of the job responsibilities do require coming into the office or going into work. An employer, generally speaking, is able to take an action because of that. But the issue that will arise is, are people who are working parents being mistreated? Is there a discriminatory impact that's happening by virtue of an employer's policy of terminating people who aren't able to go back to the office? And is there any real need for people to go back to the office if they're able to work from home? Furthermore, if certain people are being allowed to continue working from home and other people are not, an issue will arise is it being held against the people who are working parents that they are not being accommodated, whereas other people are. So it does all, unfortunately, there's not a straight answer. It does all depend. And but these are issues which absolutely implicate the anti-discrimination laws, and you certainly may have rights if a situation like that arises.
Thanks, David. All right, the next question. If I quit my job because my employer will not let me work from home, can I apply for unemployment insurance benefits or other COVID relief? So again, that depends. A lot of this depends on why you felt the need to quit your job. Is it because you did not want to commute? Is it because this is a precautionary measure that you're taking? Or is it because you have a medical need, if you're immunocompromised, if a doctor has told you you should not take the subway, you should not be in an office right now with other individuals, you really need to diminish any risk of exposure. If you have medical documentation to this effect, then you can still be eligible for unemployment insurance benefits. However, as we've discussed on other lectures and Q&As, unfortunately, the way that the new unemployment insurance law operates under the CARES Act, it doesn't let just anyone quit their job because they can't work remotely or because they're an essential employee. It really does require that an individual have medical documentation or a medical reason for quitting their job. If that individual quits their job because of childcare issues, as David talked before, that could make someone eligible for the new pandemic unemployment assistance program. But if you don't have any sort of medical issues, if you don't have any sort of childcare issues, and you just decide, I don't want to go into work because I don't want to put myself at risk, unfortunately, that would not be a reason that would make you eligible for unemployment benefits. Next, if I am feeling sick, can my employer make me stay home without pay? So under the CARES Act, there is a new paid sick leave that employers are required to provide employees with sick pay if they're suffering from COVID-related symptoms. It's not necessarily, when we say sick, we're now referring to COVID-related symptoms. However, under the New York City paid sick leave law, regardless of what type of sickness you're experiencing, you can still be eligible for a few days of paid sick leave, depending on what hours you work and how long you've worked for your employer. So if you are being told that you need to stay home and that you're not going to be paid as you stay home, you should definitely reach out to an attorney to find out what your options are, what you might be eligible for, because it's very possible that you should be paid for this time that you're home. Additionally, if you're feeling sick or if a family member is feeling sick, you might also be eligible for the New York State paid sick leave, as well as the FMLA, which is not paid. But these are two other options that you might be eligible for. And again, we highly recommend you reach out to an attorney if you think that your rights are being violated. Next, do I need to track, so this is from the perspective of an employer or an employee. Do I need to track everyone that I come into contact with at work in the event that I get sick? So the EEOC has issued some guidance on this, but essentially, if you are an employee, you're not required to disclose that you feel sick or that you may have come in contact with being sick with someone while you were sick. However, it is highly recommended that you tell your employer, because your employer has a serious interest in making sure that its employees are safe and healthy. If an employee does disclose to an employer that they are suffering from COVID-related symptoms or that they've been diagnosed with COVID, the employer is allowed to tell other employees that someone has been experiencing these symptoms or someone has had this diagnosis. However, an employer must keep the identity of this individual confidential. So as an employer, you certainly have an interest in telling your employees that they may be at risk, that they may have had some exposure, but just make sure that you keep the employee who is sick, you keep their information confidential, and that you don't violate their privacy. And this goes into the next one. If I test positive for COVID-19, do I have to tell my coworkers about it? And as of right now, under the EEOC guidance, it does not seem like there's any obligation for an employee to tell their coworkers that they've been diagnosed with COVID-19. That said, it is still best practices according to the EEOC guidance to inform your employer if you've been diagnosed or if you've tested positive, because you certainly want to tell others if they may also be positive for COVID to reduce the spread of this virus. Can my employer force me to wear masks, gloves, and other PPE at work? And then the sub question to that is, can my employer fire me if I refuse to wear masks at work? So the first one, can my employer force me to wear masks, gloves, and other PPE at work? Under the EEOC guidance that was issued a few weeks ago, an employer can require employees to wear masks, gloves, or other protective equipment. And then that will lead to the next question of, all right, well, who's paying for, who's providing, or who's actually able to acquire these masks if they're required? And the EEOC guidance states that if an employer is requiring that employees wear masks, gloves, and other PPE at work, that the employer provide these materials so long as there's not undue hardship, meaning and that is a very flexible term that we see often in disability cases where an employer is required to provide reasonable accommodations so long as they don't have to experience undue hardship. If you're not sure why your employer is requiring you to wear these protective equipment and is not providing it to you, then you can have a dialogue with your employer to see why they're not providing it. And if you don't believe that they're under any undue hardship, meaning that if it's not, if they're, that could mean a lot of things, but essentially if they can withstand reasonably providing this accommodation, reasonably providing you with this equipment, then they probably should be. And you should definitely speak to an attorney if they're not providing this to you. And can an employer fire me if I refuse to wear masks at work? The EEOC guidance is unclear on this point, where employers can require mask, gloves, or other protective equipment. It's unclear whether the employer would have the right to terminate someone if they refuse to wear masks. The chances are, if you are not a contract employee, if you're an employee at will, then chances are your employer can terminate you for any legitimate business reason. And a legitimate business reason may be that you are refusing to wear masks at work. So it's very possible that your employer could legally terminate your employment because you refuse to wear a mask at work. And if you're not sure what your rights are based on the situation, then you can certainly speak to an attorney. But there could be a lot of different factors at play to really answer that question. Is my employer required to provide masks and hand sanitizer to employees? And so this gets to the same point that I was just addressing. So an employer is not actually required to provide this to you. However, under the EEOC guidance and their best practices, they do highly recommend that employers provide this to employees. And again, an employer can say that they require it, but they're not going to provide it. That might be okay, that might not be okay, depending on the employer's situation, their size, their financial ability to purchase and provide this equipment. So it's really going to be on a case-by-case basis. Next, can my boss force me to stay home if she suspects I have COVID-19, even though I have not been tested? So under the new EEOC guidance, an employer can require that an employee stays home if she reasonably suspects that that the employee has COVID-19, right? So there must be some reason behind it. It can't just be, oh, I don't like this employee, they must have COVID-19, I'm going to force them to stay home. However, if that employer has believes that the employee has exhibited symptoms of COVID-19 or has come in contact with someone who's tested positive for COVID-19, those could be reasons that an employer can require an employee to stay home, even if they have not been tested. Can an employer require me to report to work even though I have knowingly come in contact with someone who has COVID-19 but have not been tested myself? So the EEOC guidance at this point is a little unclear. If you believe that you have COVID-19, if you're exhibiting symptoms, if you have come in contact with someone with COVID-19, then the best practices are to inform your employer and request time off so that you can determine whether or not you have COVID-19 and so that you can self-isolate so that you don't potentially come in contact with anyone else. That said, your employer may or may not be able to require you to continue to come to work, especially if you're not exhibiting symptoms. Next, and we've seen this question come up quite a lot. Can my employer require employees to have their temperature taken when they arrive to work? So normally, having your temperature taken would be considered a medical exam, which employers can only do if that's necessary for the type of work you're doing. However, given the pandemic, the EEOC has expanded its guidelines on this, and they have said even though temperature taking or temperature testing is considered a medical exam that's normally prohibited, given the circumstances and the fact that people who test positive for COVID-19 very often have a high temperature, they will permit employers to require employees to have their temperature taken before arriving to work. So this is something that the EEOC has provided guidance on. They have said that employers can require employees to have their temperature taken when they arrive to work, given the current state with the pandemic. So this is probably not a rule that will always apply, but as of right now, the EEOC does say that the employer can require this of the employee. Can my employer force me to report to the office, even if doing so means I will have to defy social distancing guidelines? If you're in a cramped office, not enough space between desks. So again, this depends, right? So a lot of essential workers, for instance, do have to defy social distancing guidelines in order to do their job. So under the EEOC guidelines, as of right now, employers are highly recommended to maintain social distancing guidelines, to have staggered work schedules so that not everyone is in the office at the same time and do what they can to help people maintain their distance. However, if you, for instance, are an essential worker and part of that essential work means defying social distancing guidelines. So for instance, if you're a medical care worker, right, and you need to be able to come in contact with patients in order to do your job, your employer can require you to do so. What steps can I take if I feel that my employer is not implementing proper safety protocols? So if your employer isn't implementing proper safety protocols, there are a couple of different things that you can do. So one thing is that you can try to engage in a dialogue with your employer. You can explain to your employer what you think the employer can do or what you can do to make the workplace more safe for you and your coworkers. If you feel that your employer is retaliating against you for bringing complaints like this, or that your employer is just disregarding these suggestions, then you can make a complaint through OSHA, which is the Occupational Safety Hazards Agency, and there's a New York State Department of Labor website that provides a complaint form for you to submit an anonymous complaint. If you also look at the governor's website, there is a place for you to submit an anonymous complaint. And so that's another procedure that you can use if you feel that your employer is not taking the right precautions for keeping their employees safe. Can my employer ask me whether I have a medical condition that places me at increased risk of medical complications from COVID-19? So ordinarily, an employer would not be permitted to ask questions about your health or your medical history or your family medical history. Generally speaking, this would ordinarily violate the disability law as well as the Genetic Information Non-Disclosure Act. However, given the circumstances, employers can make a reasonable request for medical information. So for instance, if you say that you need to work from home because you suffer from a medical condition, your employer can ask what that medical condition is. on the same note, if you are suffering from symptoms of COVID-19, your employer can ask what those symptoms are, or your employer can ask just generally if you're experiencing symptoms of COVID-19. So these are inquiries that wouldn't ordinarily be permissible under the law, but according to the new EEOC guidance, employers can ask certain targeted questions related to COVID-19 in order to protect their workforce. Can my employer require me to undergo a medical examination to determine whether I have a medical condition that places me at increased risk of medical complications from COVID-19? So this is a complicated question, and it really depends on what a medical examination is. So as I mentioned earlier, a temperature test is considered a medical examination, right? And the EEOC guidance has provided that employers can require temperature testing. However, if, for instance, if you suffer from cancer, and that form of cancer makes it more likely that you will suffer from serious and severe symptoms from COVID-19, and your doctor recommends that you stay home, your employer should not be requiring you to undergo some sort of independent medical exam to verify your other diagnosis. However, your employer can require you to provide medical documentation. So for instance, a doctor's note explaining why you need special accommodations, such as working remotely because you suffer from this other illness. Can my employer fire me if it discovers that I have a medical condition that places me at increased risk of medical complications from COVID-19? So generally speaking, the answer to this is no. Under the New York City law, an employer cannot terminate someone because they learn that someone suffers from a medical condition. And then under the New York State and federal law, again, an employer cannot terminate someone because they learn that that person suffers from a disability. So uh, if you have a medical condition that places you at increased risk of medical complications from COVID-19, that should not be an employer's basis for terminating you. The one caveat to that is if you are working in a field where you are almost certain to come in contact with someone who has COVID-19, so for instance, the medical field, and you're applying for a position in that field, and it turns out that you're experiencing symptoms of COVID-19 before the job even starts, then according to the new EEOC guidance, there may be certain options that an employer has if they believe that they're bringing someone on board who already has COVID-19. So that would be the one caveat under the new EEOC guidance. Does the ADA, which is the Americans with Disabilities Act, protect me if I live with someone who has an underlying medical condition that places them at higher risk? So this really depends. However, the ADA does have protections for people who are associated with others with disabilities. So that said, if you are someone who is married to or is the parent of someone with a severe disability, and your employer terminates you because you are associated with that person, that would be a violation of the ADA, the Americans with Disabilities Act. If my boss granted a request for a reasonable accommodation before the pandemic, is my employer required to continue providing me with the accommodation when the office reopens? So generally speaking, simply because this pandemic is occurring, that should not affect whether your employer should be granting your request for a reasonable accommodation. The only exception to that is if you requested an accommodation that for some reason the employer can no longer respect or accomplish. So for instance, if the employer was paying for some very expensive piece of equipment for you to use, and the employer cannot continue to pay for that service because they've been economically disadvantaged by the pandemic, then you may need to have another conversation about what type of accommodation you need. Aside from that, assuming that the employer can continue to provide your accommodation without undue hardship, they should continue to do so after the pandemic and after everyone starts returning to their workplace. And can my employer require employees to come into work, but only if they have no underlying medical conditions? So Again, the EEOC is a little, their guidance is a little unclear, and I think we'll learn a lot more in the coming weeks as we start to enter the different phases to reopen New York. So it really is unclear. That said, if you have a medical reason, an underlying medical condition, why it would be dangerous for you to go back to the office or to commute to work, you should definitely speak with your employer and get medical documentation showing why you are at risk and why it might be a problem for you to return to work. And you should speak to an attorney about requesting reasonable accommodations, such as working remotely if you are at high risk. And those are the questions that we had prepared. So thank you all for tuning in. It doesn't look like we have any more questions as of right now. So I'll turn it back to David for some closing words unless anyone has any last minute questions.
Thank you, Hillary. Well, I hope everyone enjoyed this, and I hope people had some questions answered, and at the very least, people armed themselves with some maybe information that they were looking for that they didn't have before. Again, the answer to a lot of these legal questions is it depends on the circumstances. So, please be vigilant if you have any questions about your rights. We have many attorneys available to help you answer your questions, so please feel free to reach out to us. Otherwise, I think that covers it. Please, everyone, stay safe, stay healthy, and enjoy your weekends.